Greetings and welcome to our lecture series for the law of equity and trust. My name is Ayub Okayo, and today I'll be taking you through our third chapter, which is on equitable remedy. As you may recall from our previous chapter series, we discussed that equitable remedies are discretionary and only granted by the court where the common law or statutory laws do not provide sufficient remedy to the plaintiff. So today we shall start with injunction as one of those remedies, and so we can understand how the court may use it and in which circumstances the court may even deny the plaintiff of such remedy. So welcome to the lecture series, and I hope you enjoy it. Now, when it comes to the injunction as an equitable remedy, it's proper for us first to understand how and why it is even applied. So an injunction is that order of court requiring a person to do or cease doing a specific action which may be deemed as injurious to the plaintiff. On its own, however, injunction cannot be a cause of action in court and can only be uh, awarded where the plaintiff has already brought an action to court and requires this as a relief from the court to protect their own interests and rights. Now, an injunction may be uh, awarded by the court against a person, either individually or as a group of people or an organization or a class of specific people, instructing them to cease unlawful acts, or at some point to compel them to undo a certain action that have already been done by those defendants. Now, this type of remedy, in most cases, it comes on to compel a party to act or cease acting. So it's more like an enforceability of certain action or the conduct of the respondent so that they can protect the interest of the plaintiff. There are several types of injunctions, and we shall be looking at these types of injunctions one after the other. And also, it's worthy mentioning that each type of these injunctions are tailored to remedy a specific harm occasioned on the defendant. So these remedies, these injunction remedies, they come in a different fashion and designs to achieve a different function in terms of remedying the plaintiff's um, um, the concerns, or rather, the harm which has been occasioned on them. Now, the first one is a prohibitory injunction, which on its own way, it comes in to stop a party from acting in a specific way to prevent them from continuous breach of an obligation. It is restrictive, of course, in nature and forbids the party from acting um, or refrain from acting continuously, which may continue to harm that plaintiff's rights. And as such, the court may say the defendant should stop doing the specific act, or they should um, uh, uh, refrain from doing it if they have not started uh, doing it. So it's kind of like stopping a party from carrying on a certain action, which, if continually done, then it will be injurious to the plaintiff. Another injunctory relief that the court may be prepared to grant to the plaintiff is called mandatory injunction. And this one, it comes to compel a party to undo um, an act which they have already done. So it is kind of enforcing mechanism that the court may use to compel the defendant to undo unlawful act that they have already done against the plaintiff. Now, there are several instances where this particular relief of mandatory injunction may be applicable, and as such, the court may give this order in more so um, to to compel even a party when undoing that which they already did before, to make sure that there's a protection of proprietary rights over the plaintiff. A good example will be the court order of injunction to compel a defendant who has encroached on the plaintiff's land so that they can demolish a building which has been constructed in another's property. Um, and the court, in most cases, requires that this um, this relief be granted most of the time near at the end, or at the point where the plaintiff demonstrates that without demolishing or without undoing this harm, then continually their rights will be violated. And remember that where these plaintiff's rights are being violated, but monetary damages can sufficiently cover the harm occasioned on the plaintiff, then the court may not issue such order to compel the defendant to act or to undo a certain action which they had done injuriously to the plaintiff. So it aims largely at undoing a wrong, which rather rather than carrying out a positive obligation by the defendant. So it's like, can you undo what you did? You came with the dump, and then you you poured on another's property. Now the court may tell you to remove it. So you're undoing something which has already been done by you, which was injurious to encroach on the plaintiff's rights. So the court will compel you to undo what you had already done. Another um, Another injunction relief that the court may also award is called the final or the perpetual injunction. This type of injunction is one which most of the time comes at the end of hearing of the merit of the case by the court. So the court may assess which remedies are adequate for the plaintiff, and should they find that we do not have sufficient remedies as a court to award to the plaintiff, which could cure the injuries which have been occasioned, and deems it fit to award an injunction at the end of the hearing of the case, then the court may award a final or perpetual injunction, which has a lifetime um, which has a lifetime obligation on the part of the defendant to never repeat the act which is injurious to the plaintiff. Of course, it goes without saying that uh, failure to honor this order will, of course, cause a contempt of court, and the court may intervene to force you to um, um, stop acting in a specific way as so ordered. So this relief can only come at the end where the court has already awarded other reliefs to the plaintiff, but deems it that sufficient. It is sufficient to award this relief because of its adequacy uh, to the damages which has been occasioned to the plaintiff, and also in relation to the conduct of the plaintiff. Say, for example, if they plead that without this kind of relief, then their rights may continue to be crushed, and also maybe if it's in relation to a specific property, maybe that property it requires to be um, maybe disposed of in terms of maybe change of title, and then this relief will help the defendant, I mean rather the plaintiff, to um, restrict the defendant from continuous violation of their right. But this kind of relief, it is final and it comes at the very end of the hearing of the matter, and other reliefs have been given by the court. But the court deems that all other reliefs that have been awarded to the plaintiff are not sufficient enough to remedy the situation, an injunction which has a perpetual underpinnings may be sufficient enough for um, uh, providing for relief to the plaintiff. You also have another type of injunction which is called interim injunction, also called interlocutory injunction or temporary injunction. This type of injunction, it is um, it's that kind of relief that comes um, at the time when the matter is ongoing, or at the inception of the matter itself. The court may find it fit to award this relief to stop the defendant to refrain from continuous violation of the plaintiff's rights until when the case is heard and determined. Its life extends just from the time of its award, which most of the time is either during the hearings or at the inception of the matter in court. And once they've already been provided with this, the court will continue with the hearing until when the matter is decided. That's when this kind of injunction will not be applicable after the case has already been decided. We have specific requirements for one to rely on this interim injunction as a remedy, which has been expounded very well in Igela versus Casman Brown case, which was dealt in Kenyan High Court in 1973. It provided for those requirement that must be met by the plaintiff when approaching the court for this kind of relief. So the court will assess the matter and come up with this relief only if they satisfy those principles set out in Igela versus Casman Brown. We shall deal with this Igela versus Casman Brown its principles in another slide. So we also have another type of injunctive relief that the court may award to the plaintiff, which is called without notice or ex parte injunction. Most of these type of injunction comes with a one party application, where a party comes as a matter of urgency, asks the court to give this order without involvement of the defendant. Um, of course, it is applicable sparingly, not always that the parties um, may easily get this kind of remedy, but the court may grant it only where it deems necessary. Um, it can also be like kind of an injunction, which is going to even unnamed persons. In Kenya, for example, we've had this kind of relief which comes uh, especially on infringement of in, intellectual property of another, like on copyright, where you find that the court has issued this kind of injunction to a party who plead that their copyright was violated, and they go to cafes, cyber cafe. They go to specific people to check, even in their computers, if they possess such materials that are breaching on one's copyright or one's intellectual proprietary rights. So, if so, found guilty, or rather, if found that they are encroaching on one's copyright rights, then the court will take action by uh, enforcing this uh, remedy to to compel the defendant to refrain from continuous violation of those copyrights. Another good example on the same ex parte injunction is a garnishee order, which is an order against a bank or on a specific account where a defendant, for example, is supposed to be a defendant's account. It's frozen at that point, and an action can only be done if the court allows that the defendant should go on. It's mostly a temporary kind of injunction, also in its nature, and it gives this third party an order to deny the defendant from access of that account. It is normally very useful, especially when you enforcing uh, an award or a judgment against a judgment debtor uh, who is an owner of an account in a certain bank. So you instruct the bank not to allow them to have access to that bank account. And of course, we have in other instances where a court may order that a specific bank account be frozen for some kind of um, for sometimes because an account has not um, been sufficiently uh, uh, conducted in a proper manner, or maybe that defendant has maybe fraudulently dealt with that particular account. So garnishee order is that ex parte order that goes against a bank to enforce against the defendant who holds an account with that particular bank. So we also have a Quia Timet injunction, which is designed to prevent an anticipatory infringement on a plaintiff's rights. Um, However, this order can only be granted by the court where the plaintiff demonstrates that there is a realistic threat which is imminent in nature and likelihood of injuring that client, I mean rather the plaintiff, if this injunctive relief is not given. So it has a higher level of proof, which is required by the plaintiff to demonstrate to court to show that indeed without this kind of relief, then their rights are likely to be infringed upon. And that has to be something of eminent. It has to happen in a foreseeable manner so that the court can easily deem that should we not grant this kind of relief, then the defendant will encroach on the plaintiff's rights. And this comes most of the time before infringement actually happens. But it has to show that imminence of injury. That without this relief, it's likely that sooner or later the uh, plaintiff's rights will be infringed by the defendant. We also have the injunctive relief, and this one is called search orders, which is also another kind of another relief of equitable relief, which um, seeks to grant the plaintiff a right to inspect and seize documents which are in custody of the defendant and which are also very relevant to their case, without which they are unable to prove their case. So the court may award this relief, which is also called Anton Pillar orders, emanating from that case which involved Anton Pillar. So the court in that Anton Pillar case, which I encourage you to read, um, have established specific requirements for this relief to be granted. And those conditions are one, that there must be a strong prima facie case which is arguable in court with the likelihood of success. Also, the plaintiff must demonstrate that there is actual or potential damage of a serious nature if these relief or orders are not given for them to inspect and seize certain document which is in custody of the defendant. And without doing so, then the plaintiff will not have sufficient ground to prove their case. So there will be that sufficient, if there is that sufficient proof that there is a potential or a likelihood of damage of a serious nature on the plaintiff, should there be no disorder to search and seize the specific documents which are relevant to the case, and then the court will, of course, be prepared to grant this relief only if the plaintiff demonstrates that kind of a serious nature of the damage. Also, there must be a clear evidence that the defendant has incriminating documents which are likely to be destroyed before the trial itself. So, of course, if the defendant is likely to destroy it, maybe they are likely to shift it to another place. So we have um, some belief, of course, backed with the truth that the defendant is doing some actions which are likely to be inferred as concealing of these documents, then you can easily ask the court to give you this search order so you can uh, make sure that you seize all the necessary evidences that are required to prove the case of the plaintiff. Of course, this can go over beyond this these civil related suits, and of course it also goes even to the criminal aspect of it. So let's say there's a fraud case which is against a company. The court may grant um, these search orders uh, for example, ESCC to go and inspect and seize all the necessary documents. And sometimes we've seen this in Kenya, notoriously, the police using this to um, um, enter into the defendant's premises to search and seize those documentation. But most of the time, this order is granted ex parte without the notice or knowledge of the defendant. Because if you do not do it ex parte, you expose the plaintiff at risk. You expose the plaintiff to the risk of missing this document if the defendant finds out that they are going to search for these evidences. They are likely to hide them if they know when they are going to be searched. So we also find the police going in wee hours, sometimes at night, to enforce this court order of search and seizure. Also, it's worth mentioning that the applicant must make a full and fair disclosure of all the material facts that is leading them to believe that there is likelihood that the defendant is incapable of cooperating and providing all the necessary information required by the plaintiff to prove their case. So that disclosure must be on the plaintiff to prove the need for this order to be awarded against the defendant. Also, the defendant must, of course, be prepared that should these orders occasion harm to the defendant, they are prepared to to take liability for such harm that comes out of it. So perhaps you're going to do a search, and then a lot of damage is caused by means of use of force when trying to access these premises, and the documents which are being covered. If there are things which will be misplaced and or damaged, then to that extent, the plaintiff should be prepared to um, to provide um, monetary compensation to the defendant. We also have the freezing orders of injunction, which is also commonly known as Marieva injunction. This order is used by the court to prevent the, the defendant from removing what um, is useful to prove a plaintiff's case from that jurisdiction of the court. So if there is any justifiable um, belief that the defendant is likely to remove uh, the to remove assets out of the jurisdiction of the court, then the court may be willing to compel the defendant um, to provide access to the plaintiff to search and seize those um, uh, assets, or rather evidences that may be useful in court. Now, there's a quite smaller difference between the search and seizure orders. Um, when it comes to seizure order, um, the court may be doing this on a specific asset, and that asset might be which is in contention. It might be the land which is in contention. At some point, it might also be in relation to the asset which the plaintiff thinks that if this decision by the court on that case action goes against the defendant might move this asset to a different jurisdiction, or they might sell this asset. So particularly where a defendant is a foreigner or they're investing in other jurisdictions, and the subject matter, um, it is the only way the plaintiff may enforce the orders coming from the court, or perhaps to even execution of their decree if the plaintiff wins the case. So the court may do within its powers um, to award this relief, which is seizure, injunction, to prevent the defendant from dealing with that particular property during the life of this litigation. So the court may prevent the defendant from any action or dealing uh, with the particular property, or they may only limit to what extent the defendant may deal in that property. They can, of course, continue doing whatever they're doing, but without having a chance to even change the legal title of that property. Now, what if the court is not prepared to give injunction? What can be done to say that the court in that regard should not give an injunction to the plaintiff, even if they have suffered some harm occasioned by the defendant? So the case of Shelfer versus City of London, um, the court provided for the rule under which a court should look at when granting this relief of injunction. And to some extent, at what point do we have an alternative to injunction? So the court will not be prepared to award injunction where damages is sufficient enough to remedy the plaintiff's uh, violation of rights. So if the defendant has violated the plaintiff's rights, but the compensation or monetary compensation through the way of damages, it is sufficient enough to provide remedy on the plaintiff's harm, then the court will not offer an injunction as either one of the reliefs or an alternative relief to the plaintiff's injury. According to this Shelfer case, there are four principles that emanated from it. Of course, it has not been followed fully. There's some kind of departures from this, and the court is adopting more flexible mechanisms on how to deal with these rules. They provided that the plaintiff, where the plaintiff's loss is small, damages may be sufficient as opposed to an injunction. Also, where the loss can be valued on a monetary basis, now we can say this is how much a plaintiff can receive at the end of the case. If so, then damages can be awarded instead of injunction. Also, where the money provided by the plaintiff, where the money will provide the plaintiff with an adequate compensation, and also where an injunction will be very oppressive and disproportionate to the defendant, then the court will not be prepared to award injunction as relief. So, damages in lieu of an injunction is that we ought to give damages at all costs. We should provide for damages as the only common law relief in most of these um, plaintiff plaintiff injuries. So we can always compensate the plaintiff through damages. However, not always damages can be sufficient enough to provide the to provide sufficient relief to the plaintiff. And in such, we have to employ other equitable remedies, say injunction, to assist the plaintiff against the defendant's violations. Now, what's the position of the case laws in with regards to forfeiting damages uh, and opting for injunction or vice versa? We have a case called Tamares versus Fairpoint, which was decided in the UK around 2000, in the year 2006. The court refused to grant an injunction uh, on defendants action uh, where they had built where they had built a building which was overlapping on the plaintiff's uh, on a plaintiff's land property, and as such, the court refused to grant this relief, stating that by demolishing a section of the building was very oppressive, so they refused to um, award a mandatory injunction to demolish a part of the building because it was going to be unequitable and oppressive to the defendant, and monetary damages could be sufficient enough to award the plaintiff the relief. Also, in the case of Reagan versus Paul, the plaintiff's right to light had been infringed um, by the defendant when they were constructing a building project near or rather adjacent to the plaintiff's um, building. So the court deemed that the relief of mandatory injunction was sufficient to stop this um, defendant from encroaching on the right to life of the plaintiff by ordering the defendant to redesign the top floor of that development project. So, in this regard, the court felt like it would be very unfair to let the structure continue to be built, and yet at the end of it all, they will continually and permanently um, um, encroach on the right to light of this plaintiff. So the court ordered that the design of the top floor of that development project be redesigned to allow light to flow to the plaintiff's apartment. Also, in another case of Coventry versus Lawrence of 2014, um, the court denied an injunctive relief to the plaintiff where nuisance action was brought against the defendant on the noise which was generated by the motorsport carried out on his land. Um, it was deemed that the court deemed that the relief of injunction was um, too oppressive to the defendant, because that motorsport was the only activity which is being done. And if an injunction was to be awarded to the defendant, to the plaintiff, then it means that this sport was not going to be continuing in that particular location, and yet they had listed the property to continue doing these motorsports in that property. So the court found that monetary damages was sufficient enough to award the plaintiff relief. Now, I had mentioned the principle in Giela versus Casman Brown, which is a Kenyan case that follows um, our Civil Procedure Act and rules. And this Giela versus Casman Brown um, was a locus classica case that provided for the guidelines when it comes to interim injunctions. Now, when you're looking at these principles of Gela versus Casman Brown in Kenya, we normally do it in relation to what the Civil Procedure Act, Cap 21 laws of Kenya provides. You cannot do it in isolation, but of course, we look at those other requirements of civil procedure on how we can take the case to court. And now that the case is in court, the procedures have been followed. The court looks at these guidelines from this case and um, uh, um, uses it as a benchmark to see whether interim injunction should be granted or should be denied. So now, the following are the guidelines which the court most of the time looks at, which emanates from the Gela case, um, that without satisfying these elements, then the court may easily deny a plaintiff of an interim injunction. So the first one, the plaintiff must demonstrate to court that there is a prima facie case with a high likelihood of success. So if they do not have that demonstration of like they have a proper case in the violation, of course, knowing that you have a prima facie case emanates from the law which has been violated. And then, of course, if you can uh, uh, if you can assess that the duty of care was owed to you by that party, and then there's sufficient evidence to prove that they breached that duty of care. So the prima facie case, once it has been established that there is one prima facie case and not a frivolous case, then the court may um, be prepared to award you an interim injunction relief. Another guideline that has also been founded in this case is the plaintiff must show that there is an irreparable harm which is to be occasioned unto them if the court does not offer this injunction to them, and such irreparable harm cannot be compensated through monetary damages. So, if so, then the court will refrain from, uh, uh, if not demonstrated that there will be irreparable harm not capable of being sufficiently compensated by monetary damages, then the court may not grant this interim relief. So the plaintiff um, um, has that obligation to demonstrate to court that without this relief, then their right will be irreparably harmed, and the monetary compensation is not sufficient enough to cure the injuries occasioned by the defendant. Another third element which has been provided is the balance of inconvenience, um, or the balance of justice, which must be satisfied by the plaintiff, or through weighing of the harm which is to be occasioned to the plaintiff should this relief of interim injunction not given, against the inconveniences which is to be occasioned to the defendant if this injunction is granted. Now, let's say, for example, we have a parcel of land which is in dispute, and we have two parties. The plaintiff is claiming this is their property, and the defendant has already constructed in this property, and the court weighs if they grant this relief at this stage, maybe to demolish or to cease from building or constructing of that property. Is there any way that the defendant is going to be injured if this relief is given? Or how is the defendant going to be inconvenienced if this relief is given? Against the plaintiff's rights, which they assert that should there be no this injunction, then their right will continually be violated. So in such regard, we may say that the court normally weighs the two options to see if they are awarding the relief to the plaintiff on interim injunction relief, then the defendant is likely to be harmed. And if the harm comes on the defendant, it is not to the greater level as compared to that one that will be falling on the plaintiff should there be no interim injunction relief from the court. Um, Also, we have another requirement that the plaintiff, when asking for this injunction, should be prepared to reimburse any financial losses occasioned to the defendant as a result of that injunction which has been awarded by the court. So the court will want the plaintiff to demonstrate that if um, this injunction is granted to them, and then as a result of that injunction, it causes a harm or financial loss to the defendant, then the plaintiff should be prepared to compensate the defendant to the extent of that loss. Now, let's say, for example, the defendant was constructing a building, and that building, uh, the court offers an interim injunction that it should be stopped from continuous construction. And then there was a timeline, maybe, for building this construction. And as a result, the constructor gets a loss which is occasioned because of the timelines, or the defendant gets a loss which is in relation to the timelines as a result of that injunction which has posted the construction itself. And let's say other um, other harm, well, in relation to the same also comes in play, and then the defendant gets a loss, then the plaintiff has to do uh, um, necessary steps to compensate the defendant for those losses that occurred as a direct result of this injunction that has been pleaded, or rather requested by the plaintiff. Um, Lastly, the Gala versus Casman Brown also finds that the 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 interim injunction as a relief should only be granted by the court as a matter of last resort, by weighing the strength of each party's case uh, to be considered by the court. So if they weigh the strength um, of the case itself and see the defendants have equally a good case, and maybe they are saying we did not encroach on this property, we have the right title, and the plaintiff also saying we have the right title, then the court may be apprehensive to award this interim injunction and wait until the end of the case merit so that they can make the orders. And if need be, they can offer that injunction. So interim injunction at some point, it may not necessarily be obvious that the court will grant you that interim injunction unless you've demonstrated that your case is strong enough to sway the bench based on the the evidences that you table before it. However, this does not mean that the court is going to assess the case at that stage before awarding an interim injunction, so they can see that there is a good case here or the other case to have a judgment. No, the court will only use the available evidences to see there is arguable case and sufficient, or rather some relevant evidences, not rather sufficient, because at that time the court has not even started looking at the matter wholesomely on its own merit. So they will look at it and see if there is sufficient, there is some evidences, not rather sufficient, but there is just some evidences that can be relied upon by the plaintiff or the defendant, so they can weigh the strength of each party's case. So if the defendant has equally a good arguable case and they have evidences to prove the title ownership, for example, on the matter of land, like in that example I've given, then the court may not readily provide the interim injunction relief to the plaintiff. Now, there are those exceptions to the Giela versus Casman Brown uh, case. And those exceptions are related to the principles that not all situations uh, can warrant the court to award that interim injunction. So the court will be assessing several things. If the defendant have a good arguable case, um, if the defendant have a good arguable case, then there's a high likelihood that the court may refrain from awarding an interim injunction. But now where there is um, there's no good defense on this, then if it's a dispute in relation to a property and the defendant cannot demonstrate that they have the right or the title to deal with that property, then the court may grant that interim injunction. Um, Also, where the if the court grants or refuses to grant such an injunction, will render the trial of that action unlikely nugatory. With this, it provides for something like this, an example where um, there is somebody like we have a newspaper printing company, and we have a story which is being published, and then at this stage of the story is coming to court, because um, the defendant is aggrieved by that particular story that's being published, and is coming to plead to court based on that particular publication. If the court only issues an injunction, then it is likely that um, the case will end there. So let's say it's an defamation case, that someone has defamed another through a publication, then the court issues an interim injunction: do not publish, do not continue doing this, for example. Then the case will end there. Then it will be uh, um, very difficult for the court to continue to the merit of that particular case. So the court may let that publication go on and not offer that interim injunction relief to the plaintiff, and let the court continue until at the end of the trial, and then it can give its um, reliefs. So in such cases, it will be very difficult for the court to grant such an interim injunction. Now, for the purposes of our class, I would request that you look at those exceptions um, to the Castman-Brown, because they are highly examined, and this whole case of Castman Brown, you should endeavor to read it, because it's one very instrumental case when we are dealing with equitable remedies of injunction. So, at that note, I will end it at this level. Um, and next week, we'll be looking at specific performance and estoppel, and perhaps a few other remedies, equitable remedies that may be um, relevant for us to discuss in this chapter module. So, with that, thank you very much, and I welcome you with any question to the lecture seminar. And please endeavor to prepare with those questions that are provided for you, to prepare and to prepare for the next lecture. So, with that, thank you very much, and have a lovely week ahead.